As part of the recent Financial Services Development Council Practitioner Speakers Series hosted by the Open University of Hong Kong, Ms. Bonnie Chan, partner at David, Polk and Wardwell and member of the FSDC Council, assesses the state of corporate governance in Hong Kong. She finds some bright spots, but also identifies serious gaps, especially in the protections offered to shareholders.
Good afternoon, everyone. I am Bonnie, and today we're going to take a look at corporate governance in Hong Kong as well as responsible investment. So first of all, if you take a look at the topic of my presentation, it sets a perpetual work in progress and a sobering look at corporate governance in Hong Kong. So this suggests to you that this will be a very critical presentation, and I want to actually tell you that corporate governance in Hong Kong in fact still requires a lot of work. All right, so first of all, we hear this phrase all the time, corporate governance. What is corporate governance and why it is important? First of all, right, it is a very fluid concept, right? Broadly speaking, when people talk about corporate governance, it is about the mechanism or the process by which corporates are controlled and directed, a very broad concept. But we do hear people say, well, you know, we encourage corporates to have good corporate governance. What's the current state in Hong Kong? Now, this is Carlson Tong, the chairman of the SFC, and this is his view of the situation of corporate governance generally in Hong Kong today. Many of the Hong Kong-listed companies are mid-cap, privately owned, and family-run enterprises to whom corporate governance is something of a work in progress. And the culture of responsible corporate practice has yet to truly set in. So he is quite critical. He's saying that, well, it's still a lot of work to be done before we, Hong Kong, can claim to have good corporate governance. So let's begin with the basics. How is corporate governance actually regulated in Hong Kong? There are a few building blocks. First of all, if you take a look at the law, obviously we have the statutory regulator, the Securities and Futures Commission, and they administer the Securities and Futures Ordinance. And there, they are mostly focused on market misconduct. So they want to make sure that if you invest in a publicly listed company, you disclose the interest you hold in that company properly. They want to make sure that the issuer, these corporates, listed companies, they disclose inside information promptly to investors. And they also deal with things like insider dealing, issue a false and misleading announcement, etc. So they are responsible. The SFC, responsible for the SFO. Then there is the company's ordinance, right? When you have a company which is incorporated under the Hong Kong law, the company's ordinance provides for certain basic protection for the shareholders in these companies. And in a way, the listing rules in Hong Kong also equalize the treatment. So if you have, for example, a Cayman incorporated company listing in Hong Kong, the fact that they've chosen to list in Hong Kong, they are expected to therefore also perform to the same standard as companies which are incorporated in Hong Kong. So the responsible regulator or agency for that piece of law is the company's registry. So SFO, CO. What else? The listing rules, very, very important piece of regulation. Inside the listing rules, you will see a chapter called Corporate Governance Code, and there you will see a lot of very specific requirements about how companies listed in Hong Kong should organize their corporate governance. For example, how many independent non-executive directors should they have on the board? What kind of compulsory periodic disclosures they should make? What kind of board committees they need to have, etc. And of course, the listing rules also have a whole list of requirements governing compliance. Once you are a listed company in Hong Kong, you are supposed to do, you know, a whole slew of things like holding your general meetings, making announcements, etc. This part, it's enforced by the Hong Kong Stock Exchange. Okay, so, you know, we see different laws and regulations. And essentially, if you think about the buckets, right, what broadly do these rules and laws provide for? First of all, the broad category of directors. They want to make sure that directors are organized in a way where they're put in certain structure, they're given certain roles, they have certain meeting procedures, There are regulations about how they could be appointed or removed. And of course, you want to sort of specify what their key responsibilities are, how they're going to be remunerated, what compensation are you going to pay to directors. So that's sort of under that category. Second broad category is accountability and audit. Imagine if you have stock in HSBC, right? You want to make sure that you understand how they're doing financially, right? What's their performance, and how do you find that out? You can only find that out when they issue their financial results. And in Hong Kong, it's biannually, meaning that they have a 6 months interim results and a full year annual result. You also want to make sure that a company follows certain internal controls and risk management procedures, and very importantly, an audit committee. So, it's such a big company, they can claim to have all these systems and procedures, but how do you know if they're following it? That requires audit, an internal audit function, which basically will go through these health checks to make sure, in fact, they are practicing what they're preaching, right? They claim to be following this. Then there is delegation by the board. Now, a company as big as HSBC, again, for example, you can't expect the board to know every single thing which is happening in the company. They have a big board, but there's bound to be some delegation, right? So the board will delegate appropriately the management function to different groups, right? It could be the senior management team, it could be other committees, and you want to have an idea as to how that is being managed. The next one, communication with shareholders. They may be doing it right, but if you are the investor and you have no channel through which you can actually find out how the company is doing, it also will not be very conducive to good corporate governance. And the last one, company secretary, that's a very important function. Big listed companies or even small listed companies, you do want to make sure that someone is there, always available, accessible to manage the company from a secretarial perspective. So this is what the CG code, the Corporate Governance Code, within the listing rules, that's the focus. You may think, okay, Bonnie, so far so good, right? So you've told me that there are all these rules, the SFO, the CEO, the listing rules, the Corporate Governance Code. We must have pretty good corporate governance, right? Assuming that the listed companies follow them. Is that the case? Now, let's see what the findings are. So every year, the Hong Kong Stock Exchange do a review. They will review all the financial reports of the 1,900 listed companies in Hong Kong, and they'll issue a report card. So let's take a look at the 2011 one. It was very good. They said 99% of issuers comply with 41 out of 45 code provisions, and satisfactory explanations were provided for most of the deviation. 99%, this is distinction. This is very good report card. However, let's see what they said in 2016. We found a few cases where issuers did not disclose auditors' remuneration. There are still instances of insufficient disclosure in the nature and impact of significant events. And then we identify a few areas in which business reviews had room to improve. Disclosure, directors' emoluments were incomplete. So they were not as quick to congratulate themselves as 5 years ago. And this is good. You shouldn't be complacent. You should really take a look at what the problems are and reflect upon them and try to make improvements. Let's actually have a reality check. I promise you this is the critical presentation, and here comes the critical bits. What actually falls short? Now, first of all, in Hong Kong, there's no such thing as class action. In the United States, and you'll read about it all the time, if, say, there is a listed company and the directors did something terrible, right? They committed fraud or they embezzled money, right? Take money away from the company, what's going to happen? Shareholders sue them, right? They take them to the court and, they will be punished. Some people may remember Enron, for example, right? That's the case where they committed, significant fraud, and eventually some of the directors of that company was put to jail. And there could also be civil action, which would result in compensation being paid to investors. But in Hong Kong, there is no such thing as class action. So if you are a shareholder, you invested in this company, and you felt that the directors were breaching their duties, right? They were, either not paying, enough care to managing the business, or, worse still, they embezzled money. What are you going to do? In Hong Kong, you cannot just get together as a group of shareholders and initiate an action against these directors. The only machinery available in Hong Kong is something called a derivative action, but that's only available in very limited circumstances. And also, it's very expensive to sue. Lawyers, I'm a lawyer myself, but we're not cheap, right? So, unfortunately, because of this, it takes away a very useful weapon against bad behavior. Over the years, there have been a lot of talk about improving this, and in fact, 10 years ago, there is a Law Reform Commission initiative. They formed this class action subcommittee, and they were trying to figure out whether or not there's a way to introduce class action into Hong Kong. Now, after 10 years, they have made very small steps, and they said, okay, we can make some proposals for class action, but let's start with like consumer cases. In United States, for example, if there is a sort of some medication, right, which turn out to be bad, people can sue in a class action. Hong Kong is beginning towards that direction, but so far as corporate governance is concerned, still no class action. So that's first reality check. Second one, shareholders redress. In a similar vein, right, I told you just now, it's very expensive. In a lot of jurisdictions where shareholders, right, if they really think that, the company's directors have done something terrible, they want to sue, they can actually hire a lawyer on a contingency basis, right? So the lawyers would say, okay, I'll represent you, I will do the litigation for you, and I will share in the compensation on a success basis. So if I win, I share. If I don't win, you don't need to pay me a single dollar. In Hong Kong, that's not allowed. So contingency fee arrangement is not allowed. I'm a lawyer, I must charge you if you want my service. And there is also the loser pay system. That's even worse. What does that mean? That means if you go and sue a company and you lose the litigation, not only do you need to pay your own lawyers, you need to pay the legal cost of the other side. The party who you sued and now, has won the litigation. That's called the loser pay system. So just imagine, if you are the investor, even if you really think that someone was unfairly treating you, you don't want to sue because it's so expensive, and if you lose, you're going to be bankrupt. So this is another reason why in Hong Kong, right, shareholders' interests are just not very well protected. Now you may say, do we not have shareholders activist group? There is David Webb. He's supposed to be, the champion of good corporate governance. Yes, he's very active, very vocal. He's very critical of bad corporate behavior. However, he's just one of very, very few. And it takes a long time for people to actually be aware of, these initiatives. Unfortunately, that's not going to help much. Shareholders' empathy, right? A lot of times, investors don't really care. They buy the shares and they just want to flip very quickly, earn some money, and that's it, right? They're not going to attend the AGM and then raise their hand and ask very challenging questions to the management of the company. The regulators, what about the regulators? The SFC, the stock exchange, why are they not taking care of the small investors? They are, but I will tell you later that their weapons are actually very few. So we didn't really do well in class action or shareholders redress. How about relying on the independent non-executive directors, right, to take care of things? They are independent, right? So they should really be representatives of the minority shareholder interests. Now, first of all, what do the listing rules require? At least 3 INEDs on every single board of listed company, and out of which one has to have professional qualifications on an accounting or financial management expertise. INEDs must make up at least 1/3 of the board. So if you have a 10-member board, you need at least 4 INEDs. However, I can tell you in reality, first of all, it's very difficult to find good INEDs. There are not a lot available. And then the independence is a little questionable, because just imagine if you are, appointed by the controlling shareholder, right? He has the votes to vote you to become an INED. You may not want to really disagree with him too much, right? Otherwise, the next time around, he probably will not vote for you. So there is a bit of a disincentive to do something to rock the boat. Also, the last point, which is very important, you can't be sure that they would even turn up Now let's take a look at 2 annual reports I've found, and let's see how the INEDs perform. So this one, with 3 INEDs, out of 18 meetings that year, they attended none. So I don't know how you rely on these 3 people to watch out for your well-being. Another one, this one slightly better. They attended 3 meetings out of 17 in a year. So, even if they don't show up, chances are they will be reappointed, they will earn their remuneration as director, and that's it, right? You are the poor investor in this company, you really don't have a lot of channels which you can complain about this kind of behavior. Closely held listed company. I think this is another very prominent feature in Hong Kong. A lot of the listed companies are actually family-owned. The Hong Kong requirement is that you only need to issue 25% of your outstanding capital to the public. That's called a public float. It's quite common the case that in a Hong Kong listed company, you have the controlling shareholder holding as much as 60%, 70% of the company. And if they have such a big chunk of controlling stake, they can vote everything through, almost, right? So if you think about that, it's very difficult to introduce changes, good corporate governance practice, because the controlling shareholder is probably going to think that doesn't help me make money. I mean, it's just going to introduce costs, right? And they will not really warm up to those ideas. The list goes on and on. Shareholders don't vote. Okay, why is that the case? In Hong Kong, and occasionally reporting season, right? You will see how some listed companies, when they hold their AGM, the shareholders do like to go because, they serve them very good dim sum, right? And they have nice giveaways, right? So around that time, usually the financial press will report on what kind of food they're serving at the AGM, right? Hong Kong has a very funny shareholding system, which is called the semi-dematerialized trading system. What does that mean? That means most of the shareholders, right? If I am a shareholder in any listed company in Hong Kong, most likely when you go into the share register, you cannot find my name. I will be holding my shares through CCAS, well, actually through a broker, which is, registered with CCAS, and that's it. And because of that, when the company has any important corporate actions they want to put to an AGM to vote, I don't even get any materials. I don't even get the shareholder circular because my brokers will be just sitting on it and not distributing to me. And chances are I've already signed a customer contract saying that, I give up access to those, right? So as a result, a lot of these value-destroying decisions, for example, connected transactions, they are voted through because so long as those who are present and voting, a majority of that vote for those resolutions, they will be passed. So for most of the shareholders who didn't even know that there is such an AGM, and they never, received the invitation to go, they just sit there and, these bad things will happen to them. So another big problem in Hong Kong. The next one, a toothless tiger. What I mean, it's, going back to the regulators, right? I did say earlier that, maybe we can rely on the Hong Kong Stock Exchange or the SFC to help us a little bit. But you have to understand that actually they do not have a lot of power. For example, if you are talking about Hong Kong Stock Exchange, right? Let's see what's in their arsenal. They can privately reprimand a company or their directors. They can issue a public statement and criticize them. They can issue what is called a public censure, although I don't know how that differs from a public statement plus the criticism. I mean, it's sort of like slapping you and slapping you harder, maybe. They can report the case to the SFC and the CCB and other with bigger powers. They could issue something called the cold shoulder order, which is to tell the rest of the market, don't do business with this guy, he's a bad apple. And they can theoretically suspend a stock or delist the stock. But we don't like to do it at the exchange because if you do that, who actually gets punished? It's the investor, right? I invested in this company and now my shares are, evaporated, the value, because it's delisted, right? So you should be punishing the directors, not me. Oh, the last one is my favorite. Compulsory director training. We used to have these disciplinary hearings, and at the end of it, we'll say, okay, these directors are terrible. We must punish them. So how many hours of training should we make them sit through? right? And usually it's about 24 hours. I actually have to give a lot of those trainings because, I'm a lawyer, right? So usually when a director gets that penalty, they will call up a law firm and say, can you come over and give a training, right? And when I do, they're usually either dozing off or they're checking their BlackBerry, Candy Crushing. So not much the Hong Kong Stock Exchange can do, unfortunately. Now, I've painted a very grim picture. So far, nothing sounds good. Where's the market headed? I mean, is there actually any hope? Now, actually, the market is trying to do a lot of things to improve corporate governance. And over the years, right, on this page, you'll see a lot of initiatives which people worked on. In 2007, for example, there was a consultation about quarterly reporting. The SFO in 2012, that was much improved to put statutory backing behind insider information disclosure, etc. A lot of initiatives. However, right, I would say all those initiatives, we did make some slight improvements, but a lot of them never made it to the finishing line. So, for example, statutory backing for the entire notifiable transaction chapter, that was stalled. Connected transaction, right? So if you breach a connected transaction rule as a listed company in Hong Kong, you did not actually breach the law. You breached rules, right? So the stock exchange can punish you by either public censure or public criticism. Blackout period extension, that did not go through. Quarterly reporting did not go through, right? Hong Kong is still doing just a biennial reporting for financial results. And then giving more powers of INED, we tried to do that, didn't happen. And of course, last year, we all know about the Alibaba incident when people are talking about whether or not to give weighted voting rights or dual-class shares to Hong Kong-listed company, and that debate didn't even start, right? A consultation was stopped before it actually went up. But there were some fine-tunings. So this page, you'll see things which actually happened. So, for example, Chapter 14A on connected transactions, we did make some improvements, for example, in terms of seeking auditors' confirmation for continuing connected transactions, etc. And then for the code requiring management to provide monthly updates, that sounds so basic, but we actually needed you to work on it quite hard to get it. So that's basically where we are. Over the last 5 to 10 years, we had a number of fine-tunings, but not any major breakthrough. And we still have a lot of gaping holes. A lot of things are just not right. For example, we have general mandate, right? So each year, a listed company can issue as much as 20% of its total outstanding shares as new shares, so long as they issue it within a 20% discount, right? And that is dilutive to anyone else who holds shares in the company but is not given a right to participate in this new issue. And availability of class action, which I mentioned just now, these things are still not fixed. Unfortunately, I don't think we see a tangible, feasible timetable which these could be achieved. So, pretty sad. However, I would say people are more aware, at least. And sometimes I think the media is doing a lot of good work in this area. They report on corporate governance violations. And, when these things make it to the press, and you're running the company, you are the CEO, you are the chairman, you cannot just turn a blind eye. People are criticizing that your company has bad corporate governance. You have to react. So I think it's a good thing that there is the media and the public, watching over bad behavior and reporting it. At the end of the day, unless there is a real cost, well, I think a lot of people just would shrug their shoulders and say, whatever, right? Even if there's a bad article about me, I'm not going to change. However, if you tell these businessmen that their bad corporate governance is going to translate into real cost, that may make a difference. And this is where I think there is hope, right? A lot of very important investment funds, fund managers, private equity people, they've come out and say, look, we have adopted this policy and we will focus on putting our money only to companies with good corporate governance. So here you see these very important investors. They say, we are going to look at these companies and figure out if they have a good corporate governance. If they don't, we will not put money on it, will not buy their shares. So I think this is a good direction. And how about investors? There is a lot of study into investment decisions, responsible investment. I think a lot of these studies, the conclusion is that if you have a well-governed company, it's going to translate into better stock price. It will be reflected in a higher valuation. So over the years, you see more of these studies. This one in particular, quite interesting, the IFC survey. You see that, a lot of fund managers' decision actually do take into consideration how good or bad the corporate governance of a company is. So a lot of firms would say, my firm would pay a premium of at least 10% or 20% for good corporate governance in these emerging market companies. So if the businessman is being told, look, focus on improving your good corporate governance because it's actually going to reflect in your stock price, and because you own shares in the company, you are going to benefit, that may change behavior. All right? So I think that's how it's headed towards the right direction. And you also have index company like Hang Seng Index. They compile corporate sustainability indexes, and the big fund managers will track these indices before they make investment decision. Lastly, on responsible investment, I talk about how changing behavior on the part of the issuer is important, on the regulators is important. However, there's also a concept called responsible ownership. You are the investor. You have made an investment decision to put your money on this company's stock. You should also be responsible, right? You should do your homework and make sure that, you play your part in correcting behavior. So the SFC actually earlier this year published 7 principles of responsible ownership, not binding. I mean, that's supposed to guide institutional investors to start with as to how they make their investment decision. So these are the 7 principles. For example, you should establish and report to your stakeholders, right? How you've discharged your ownership responsibility, monitor and engage your investee companies, etc. Clear policy on voting, right? If you're a fund manager, you better make sure that you attend meetings and vote your shares one way or the other, etc. So these principles, what are they here for? So if you are, someone with the money to invest, you should tell your stakeholders, right, whether or not you have adopted these principles and how you are implementing this. And the SFC is saying for those licensed entities, the MA, the Provident Fund Association, etc., these are statutory. They get money to invest because you guys are contributing to it. They should be the ones first to adopt these principles and report to their stakeholders how well or not so they're doing. This is how eventually market impact could be made. Times are changing, and I think companies need to be more mindful of their corporate governance because, it's on the positive side, it's going to translate into better share price. On the negative side, there are these shareholders, right? Even though there are toothless tigers, you may be hit by muddy waters, and that's going to do very long-term damage to your company. And the regulators are paying more attention. They are having even more powerful weapons in their arsenal. So ultimately, I would summarize it to basically it's a question of motivation, right? There's the carrot, which is better stock price and more long-term investor following. That's the stick, which is all these bad things, media reports, short sellers attack, regulators punishing you. That's the stick. So it's a question of motivation, right? If you get the balance right, then Hong Kong may have a chance to get to a state of better corporate governance. And that is the end of my presentation. Thank you.